We want to share a successful case of our firm with you today. 10 months after our client submitted his I-485 application to register permanent residence, our client received an interview notice from USCIS. During the interview, the client acknowledged his active Communist Party, also known as the CCP, membership. After the interview, our client received a denial notice. Let's first take a look at the reasons provided in the I-485 denial notice issued by USCIS. The client confirmed that he had been a CCP member within the 5 years immediately preceding the filing of the green card application. He explained that his membership was voluntary. He claimed that his membership was not necessary by operation of law, or that it was for obtaining employment, food rations, or other essentials of living. The client had been a member of the Communist Party for a decade and had not terminated his membership. According to U.S. immigration law, the client is not qualified to adjust his status, and USCIS denied his Form I-485. After receiving the I-485 denial, the client resubmitted an I-485 application with an I-601 waiver application. Unexpectedly, the two applications were denied again 2 months later. In the I-601 denial letter, the USCIS explained that the client's qualifying relative had only demonstrated ordinary hardship but not extreme hardship. Thus, the second green card application was also denied because of the denial of the I-601 waiver application. Later, the client realized that this case desperately needed to be handled by a professional lawyer with extensive experience in waiver cases. Therefore, the client made an appointment with the law offices of Sabrina Lee. Our office conducted a detailed evaluation for the client and provided professional advice. When assessing whether a qualifying relative will experience extreme hardship, the USCIS officer must consider all factors and consequences, both in their totality and cumulatively. There were several difficulties in the case. First, the client's I-485 application had been denied twice, and if it was denied again, the client might have been referred to immigration court for removal proceedings. Second, on top of that, the client submitted an I-601 waiver once by himself. If the waiver application submitted a second time was not significantly different from his first one, it would likely be denied again. Third, the client had only one qualifying relative in the United States, and that was his adult child. It is relatively difficult to prove that adult children would face extreme hardships when their parents are forced to leave. However, our office was confident that we could help the client submit a successful I-601 waiver application. After the consultation, the client believed that our office had made a very convincing analysis, so he did not hesitate and hired our office as his attorney for his I-601 application immediately. Our office did not disappoint the client, and our team quickly prepared and submitted an application materials for the client. In the end, the client's waiver application was approved, and the client successfully obtained a green card. If you or somebody you know find yourself in a similar situation and you need our immediate assistance, our offices are here to help.